The following is a paid program brought to you by My Philly Lawyer. The views and opinions expressed are those of the sponsor and do not necessarily reflect the views and opinions of the station and its management.
Good morning. Court Radio is now in session. Call 215-227-2727. When you've got legal questions, we've got the answers. This is Court Radio. And now here's your host, Dean Weitzman.
The 22nd. My, how the year's flying by, and we've been inundated with rain, and it looks like today's going to be another rainy, cold day. So sit back and enjoy Court Radio for the next hour while we tackle your legal questions. All you have to do is give us a call at 215-227-2727. That's all you need to do. Just give us a call at 215-227-2727 from 7 to 8. That's the number for Court Radio. Thereafter, you'll get My Philly Lawyer. So, we got some legal issues in the news we're going to talk about, but I also want to introduce our guest, the one and the only, Irina Shiloh.
Good morning.
Good morning, Irina. Welcome back to Court Radio. Wow. Your fans are adoring you. Yeah, so you know, folks, if we got Irina on the show, we're probably talking about domestic relations issues, custody, child support, how to get rid of that guy that never seems to do what you need him to do. So we're going to talk about all those things in just a minute, but let's talk a little bit about what's going on in the news. First of all, we have an interesting article from Center City, Philadelphia, where a woman identified as Mariandeli Miranda was charged with attempted murder and leaving the scene reckless driving when she used her vehicle as a weapon. She had an altercation with a pedestrian and ran her over. So the question is, aside from the legal interest in that story, the question is, can the pedestrian sue her attacker? Sue her, when I say that, I mean for money damages. And the answer is obviously yes, she can. But guess what? The attacker's insurance company won't be responsible to pay any judgment. So she's going to be left with having to try to get money from the attacker herself, because insurance companies cover us for our negligence, for our for our mistakes that we make as a driver. They don't cover us for intentional acts. They don't cover us when we use our vehicle as a weapon. So the attacker is going to be prosecuted criminally, and perhaps in that process, the victim can get her medical bills paid. But it'll be very difficult for her to see any substantial money damages as a result of that action. So that's what's going on in Philly. Guess what's going on in Vegas? In Vegas, a Fridays accidentally served an 8-year-old with a heart defect alcohol instead of a root beer. I guess he got a real beer. And the question is Fridays responsible for their negligence? And of course, yes, they are. If there are damages, if the 8-year-old sustained damages as a result of that ingesting the beer, then of course whatever damages flow from that, he can be compensated for. But if there were no damages, or the damages were so minimal, like he had a headache for a day, let's say, and then was back to normal, while they're responsible, the amount of money they would be asked to pay is nominal, very small. And so it's often, when you come to see an attorney, it's often important to talk about not only what happened from a perspective of, what the actions were of the person who caused you harm, but it's important to talk about the harm itself, because that's really what an attorney is going to evaluate in order to decide whether he or she is going to take your case. Are there damages, and to what extent are those damages? And each attorney is going to have a different threshold. Some attorneys won't touch a case unless it has value in the millions. and others will take a case if it has value in the a few thousand. So it's important to really hone in on what damages the actor who caused you an injury, what damages he caused you or she caused you to sustain. So that's what's going on in the news now. Let's turn our attention to Irina. Hi, welcome back to Court Radio.
Hi, thank you.
Yeah, we missed you the last time you overslept, but I think we did our show.
You woke me up and we did it on the phone.
Yeah, we did a remote show. But today you're live and in the studio, and things are, I got to say, I mean, I know that we're going to talk about domestic relations, a lot of different questions, but I really want to start with one kind of thing that needs to be tackled early on in someone's representation, and that is once somebody comes in and wants to get divorced, you prepare something called a complaint in divorce,
Right.
and that gets filed with the court.
Yes.
Okay, so that's kind of the opening salvo. It's how we begin all of our actions on behalf of our clients.
Yes, that's correct. And also there's a bunch of other documents that go with a complaint, so which is why it's important to have an attorney file the divorce, because I know from people have told me that it's very hard for them to prepare the papers. They don't know exactly, and there's several steps that need to be done, and they depend on whether the other party consents or doesn't consent, so it's really complicated. Everything else you could possibly go without a lawyer, but if you have a divorce, I strongly recommend that you hire a lawyer to do the divorce for you.
Now, when it's an often not thought about process in this filing of a divorce, but when you file the complaint with City Hall, okay, or the county in which the person resides, and you get back your copy that's stamped by the court saying, hey, we got this, thank you very much for filing, that's just the beginning, but there's an important step next, and that is the complaint must be served upon the other party. And served, what does served mean?
Served means that the other party, let's say the husband, needs to get a hold of the complaint. And there's ways to do it. You can't just mail it to them. You have to mail it certified letter, restricted delivery, which means that he has to take it and sign it. Or it can be served in person, but not by someone who is your relative or your employee. It can be a friend, but then the friend has to be willing to personally serve the person and then sign an affidavit and notarize it. So make sure when you ask a friend, that friend will go that far for you.
Now, if we're filing the complaint and we serve the complaint, we serve it normally by a process server, somebody who we pay to bring the complaint to the other party's attention and to hand it to them. But here's the rub here. So many people are separated for so long, for literally decades. I mean, I've gotten clients who haven't seen their spouse in 20 or 30 years. And they finally, I don't know why, but one day they wake up and say, okay, today's the day I'm going to divorce that bum. But they don't have the slightest clue where he or she is.
Yeah, that's a problem. And I always tell people you have to find out where they are, because we don't do that. We're not private investigators. I mean, you can hire a PI to do it, but we can't find your ex. We have no idea where he is or she is. So I tell people, try their relatives, workplaces, Facebook, anything where they could be remotely there, and ask people. So, and
it gets even crazier when you know they've left the jurisdiction, but you don't know where they are, and time has gone by, and they've moved, and jobs have changed. And what happens if you literally can't find them?
Well, you have to document all the methods of your attempts to find them. And with that, you go to court and you ask the judge for permission to serve them by publication. So people sometimes mistakenly think that you can just file a publication in a newspaper and that's it. They're served. That's not proper, and it has to be with the court's permission.
And guess what, folks? When we, the attorneys, have to go to these lengths just to serve a complaint, it gets very time-consuming and very costly. And so it is in everyone's best interest, because I don't want to charge a fee if we don't have to absolutely do that type of work. So it is in everybody's best interest to keep tabs on the bums that you were once married to and are now separated from. But one day you might decide the time has come to officially and legally end that relationship. Because, if you don't end that relationship and you pass, your spouse, who you haven't seen forever, could possibly come in and take 1/3 of your estate as his or her spousal share, even if you've written a will and taken them out and disinherited them. So if for no other reason, then you want to make sure that they don't get your property. You need to legally finalize that relationship. All you have to do is give us a call at 215-227-2727 and ask for Irina. And she'll get together with you, probably in our Northeast office, and get the ball rolling. But until that happens, at least keep track of where he or she is.
Right. And I also want to encourage people to start whatever process they have, custody or divorce, to do it from the beginning with an attorney. Because many people first screw things up and then they find an attorney, and now we have to repair the damage that's been done by someone else or by ignorance. And it's really hard to review everything and go back in time and then continue. It's really so much easier to do it from the very beginning with a lawyer, and then I can take care of everything and advise them accordingly, and they're not going to make mistakes.
Absolutely. Absolutely. And, the earlier somebody gets representation, more likely than not, the less expensive it is, because we don't have to undo those mistakes. And we can just file it the right way, and it's not all that expensive. If you're not fighting with the other party and there's not much to fight over, then it becomes a fairly simple process. All right, let's take a couple calls. Let's talk to Terrence on line 4. Thanks, Eric. Hey, Terrence, welcome to Court Radio.
Hey, good morning, Dean. How you guys doing?
We're doing well, thanks. You are calling from Elkton, Maryland, the place where people run away to get married. When I was a kid, I think one of my sisters might have come down a ladder out of the back door and eloped in Elkton, Maryland, because that was a place where people could get married who were minors. Yeah.
Yeah.
That was a tradition. My tradition in my family was to get married early and have babies. Yeah.
Oh, okay.
Well, anyway, aside from that insanity, what are you calling for, Terrence?
Hey, Dean, I have a question. I want to see if my daughter can do something or I can do something. My daughter went to the hospital last week, and she was complaining about she couldn't breathe. And so she has asthma, but it wasn't asthma related. So the hospital, I asked them to do a CT scan, and they refused. They said, well, we did a chest x-ray. There's no need. The next morning, they discharged her. She's still complaining about she can't breathe. They sent her home with asthma medicine. I took her from that hospital to another hospital. They did the CT scan, and the doctor came and said, guess what? You have pneumonia.
Okay. So here, all right, I got it, and I'm gonna give you the answer, because we were just actually talking about this morning before we went live, and that is, you have a case. Now let's assume for a moment, and it's an assumption I'm going to make, that your recommendation was medically the right thing to do. Okay? Because you're not a doctor, I'm not a doctor, and we can say, run this test, run that test. It doesn't mean it's medically necessary, but as fate would have it in your case, it seems like it was. And so let's assume that her symptoms, because that's really all they can go by, let's assume her symptoms on the day she was at that hospital were such that they should have done a CT scan. And they were negligent, for not doing it. Okay? That's an assumption. When you have a medical malpractice case, you need another doctor, and in this case, probably an emergency room doc, to come in, look at your daughter's chart, and say, hey, based on the symptoms this child presented with on this day, they should have run a CT scan. Their failure to run that was negligence. You need to have that opinion from another doctor in order to pursue your claim. But again, let's assume you get that opinion. Second step, what damages did they cause? You rectified the situation quickly within 24 hours. And so she got the appropriate care. So the only question is, what's the value of whatever happened to her over that 24-hour period that should have happened 24 hours sooner? And if that value is, let's say, $1,000, the answer is yes, you can bring a medical malpractice suit, but no, you'll never find an attorney in America who would bring that for you, because they're going to base their case on, hey, what am I going to recover for this family? Am I going to recover $100,000? Will I make a $40,000 fee? Will I be able to cover my costs of $10,000 to hire this doctor who gives me this opinion? And the answer, if the answer to that is no, there's not enough damages here to warrant bringing a claim, then even though you had the first part, the negligence, you don't have the second part, and you're not going to pursue your case.
Okay.
Does that make sense? Do you, you understand?
That makes sense.
All right. All right,
Yes.
Terrence, thanks for calling from Elkton, Maryland, and have a great Sunday.
Hey, thanks, Dean. You guys do the same.
Bye now. All right, let's talk to somewhere here, Richard. Richard from, I can't read this, South Philly? Yo, Richard, welcome to Court Radio.
Hey, how you doing this morning?
Good, thanks. Where you from? Where you from?
Southwest Philly. I'm at work now.
Southwest Philly and at work. You're on break right now?
No, I'm a security guard, and I got plenty of time on my hands.
All right. All right. So what is it you want to ask us?
Okay, I'm separated from my wife, and I'm filing for a divorce. I have a life insurance policy. Now, when we were together married, I'm a husband who hands his wife the money and she pays the bill. So my wife is very thorough, and she's way smarter than me. Since I'm filing for the divorce, I asked her about my life insurance policy because I want to change it. For the past 2 months, she's telling me she's been busy. She hadn't get a hold of it, but I pay $55 a month. She called me up for the money, but I said, okay, well, can you please give me the policy number? Policy, and who am I insured on? And she keeps putting it off. So, and when I told her that we are filing for divorce, she doesn't even answer my phone. Doesn't even answer the phone call anymore. Now,
Okay.
I just want to find out would I have to go through the divorce procedure to find out my policy or what?
Well, I mean, first of all, is she paying it with a check, I guess? And is it?
I'm hoping she's been paying it. It's been 3 months.
Uh-huh.
I've been handing her $55. And when I asked for it, that's when
Yeah, well,
she just...
Okay, well, I mean, you could always, I guess, I don't know what kind of policy it is. Whole life, does it have value? Does it have cash value? Is it just a term policy? If it's just a term policy, then there's no value unless you die, and in that case, you might find it just as easy to get a new term policy and stop giving her the $55.
Yeah, but I've been paying this policy for almost 5 years.
Right. Well, that's the question. Yeah, I don't want you to throw something away that has value, and clearly,
Right.
if you have a $55 payment and it would go up if you got a new policy, then I would say keep the policy. The question is, if you don't know who the insurance company is, the answer is yes, I suppose through the divorce, through discovery. Can you get that information?
Yeah, you can get that information through discovery.
Okay.
Relevant.
So in the divorce process, you could actually, your attorney could hand questions over to your wife to answer. And one of those questions is, who's the life insurance policy? Who's the owner of the policy? Who's the beneficiary of the policy? And who's the insurance carrier?
She's a beneficiary.
Right. Well,
Right.
okay. And who's the owner? You must be the owner. That means that it's
Yeah,
your...
I'm the owner.
Okay.
But like I said, she won't give me any information.
Right. And you can change the beneficiary with one piece of paper, a beneficiary
That's what
change
I
form.
wanted to.
Right. But you
That's
just
what I
don't
wanted
know who the carrier is. Where did you get
Right.
this policy?
Well, she works for Prudential Insurance Company.
Uh-huh.
She's been retired. She's been retired, and again, I trust her. But since going through the divorce and then have the new girlfriend.
Wait. She's thorough. She's way smarter than you, and you trust her. Why are you getting divorced?
Because we don't. We the argument is just unbelievable. The argument,
Okay.
Leaving a cup in the sink, leaving something, it's just ridiculous with the argument. I'm tired of the argument.
I got you. All right.
Almost to the point that we almost got physical one time. I'm 64 years old. I'm not going to be fighting nobody.
No. If it's going to get physical, it's time to say goodbye. So, all right. So again, you can serve them with questions. These questions are called interrogatories, and she has to answer them as part of the process. And you would ask her the questions about the policy.
But the divorce has to be filed.
Yeah, there needs to be a filed divorce.
Yeah. And as soon as it's filed, you can immediately do them.
But again, as Irina said, this starts to get complex, and you should have representation so that you can make sure that you dot your I's and cross your T's.
All right. Thanks for the advice.
All right, Richard, take care and have a great Sunday.
I love your show. Can I get a T-shirt?
Can you get a T-shirt? Yeah, hold on the line, and I'm going to get Monica to get your address, okay?
Okay. All right.
All right, thanks, Richard. Just stay on the line, bud.
Thanks for your call.
All right. So, Eric's looking at how do we put him on hold. There we go. All right. See, we're a technically savvy group here as they consult with one another over a held call. Okay. 215-227-2727. Do you, Irina, do you often, on complaints of divorce that we file, do we often serve interrogatories?
No, it's not that often. Because it's usually not necessary. Many people don't have any secrets, any estate to share, so we don't often do that, but it's done.
It's done. Okay, so discovery, because that's a routine process in civil actions for injuries. Always, we serve interrogatories or questions to the defendants, asking them a multitude of questions about the accident or the incident or the treatment, and we get a lot of information that way.
Yes, and we can serve requests for production of documents, too, with the interrogatories. And just for, in the name of full disclosure, they don't have to answer every question. They can object based on that something is irrelevant. For example, if you ask what's the names of the children of your new companion, that might be objected to, and people could say, well, that's none of your business.
I see. Okay. So not every question is going to get answered, but the relevant ones that are important about the division of property, those are going to have to be answered. And if they're not answered, we can go into court and the judge will issue an order forcing them to answer.
Correct.
All right. Let's talk to Lori on line 3 from Germantown, Eric. Hi, Lori. Welcome to Court Radio.
Yes, good morning.
Good morning to you. How are you?
I'm calling because I have a nephew who lives in another part of Pennsylvania, and he's going through some issues with his jurisdiction trying to charge him for paternity for child support. And there's no indication or proof that the child is his. And when he's petitioned for a paternity test, he's being denied. He owes them quite a bit of money. And at the same time, he's now on disability. And it turns out that he's been incarcerated for the lack of payment for child support. He wanted to find out what his recourses are and wanted to know how he could go about getting legal assistance.
Let me ask you.
First of all, get a paternity test.
Lori, let me just ask you a basic question here. How old is the child that we're talking about?
Now I believe she is in her teens, so she's somewhere between maybe 13 and 17.
Right. See, this is one of those classic examples of too little, too late, probably. But I'm going to let Irina talk to you about it.
Yes, he has a responsibility as a father. He probably lived with her, with the child. So once the child believes that you are her father for 13 or 14 years, you can't just say, go back to court and say, you know what, I'm not the father. I mean, you
He
can't.
never lived with the child.
Okay. But the child thought that he was her father?
This was a situation where it was a one night stand, and this person basically told him that she was pregnant, and there was no indication, there was no physical proof of whether the child was his or not. And when he tried to get paternity tests, he was denied that.
Yeah, well, again, I'm going to presume because of a time limitation issue, if you're presumed to be the father for a long period of time and you don't disprove that fact, the longer you wait, the more intractable that relationship becomes, even if it's not based on reality. Unfortunately, but that's, if that's why I asked the question, because if this child were 6 months old, this is an easy issue to resolve. You go in, the court routinely orders paternity tests of babies for people who claim that they are not or don't believe that they're the father. I don't know when, and you haven't told us, when he first requested paternity, which was quote-unquote denied. But if it were years after this child were born, and for all that time the courts were presuming he was the father and this woman was telling everybody he was the father, then it becomes a much more difficult process and maybe an impossible process to undo. If he was offered paternity when the child was in her a few months old, or if there was a good reason why he didn't, like you say, he was incarcerated and didn't have notice of any of this for years because of his incarceration, then I think there might be an exception. But ordinarily, you have to kind of work these things out promptly. And if not, bad things happen to good people.
True. And there's a lot of case law on this topic with children with presumed fathers, whether they're married or not married, and courts find it very difficult to deal with these cases because on the one hand, we don't want to charge non-fathers with child support, especially if they thought if they were lied to. But on the other hand, the courts are trying to protect the children. So if the child thought that somebody was her father, the courts are just very reluctant to say, okay, you know what, you don't have a father at this point.
Okay, so let me ask you this. Is there someone that he can speak to within your office? Because it's my understanding that per my suggestion, he called before and nobody ever called him back. So because he has specific information, would he be able to give someone a call?
Yeah, that's not a problem. But typically on domestic relations matters, other than a 1 or 2 minute conversation to kind of get the lay of the land, you're not going to get an attorney to sit down and do a complex analysis of the law and the facts and all of that for free over the phone. So what happens is when a client calls for this kind of an issue, we schedule an appointment, sit down, look at all the papers, pull all of the old records from court, and give a real answer over a period of time, and that's called a consultation, and they pay a fee for that depending on how long and how much work is done. If your nephew lives in, Wahoo, Pennsylvania, then my best suggestion would be to find an attorney in Wahoo. Okay, because he's probably not going to travel to Philadelphia to do this. But if he wants to, he's more than welcome to call us. And he would ask for Irina directly, right off the bat. As soon as he calls, he asks for Irina, and we'll schedule him, and she'll have a consultation over the phone briefly, but not going to get into the real deep meat of it because it's impossible to do that over the phone.
Yes,
understood.
And it's a lot of responsibility to give advice. It's not just a question that I can answer just simply. I take a lot of thought into when I represent people. I think things through before I tell my clients what to do. And sometimes I'll tell them, you know what, actually, let's do something else. I think this didn't work or that didn't work. We just go by we play by ear according to the law, but it has to be a process. I can't just tell him in advance, this is what you have to do, and that's your...
All right.
Thank you very much
Lori,
for your help.
Lori, thanks for calling Court Radio. Have a great Sunday.
Okay. You do the same.
Folks, we're going to take a quick break, 2 minutes, while our sponsors have their way with you.
You were just hurt. It's not your fault. You're in physical pain. How do you get better? Who is going to help you recover? West Philadelphia Associates has highly trained doctors and staff that can help you today. Don't wait at a hospital. West Philadelphia Associates will work with your attorney, providing documentation of all injuries and the best plan for treatment to get you back to the life you deserve. With diagnostic studies to better detect injuries, West Philadelphia Associates doctors and staff will help you recover. West Philadelphia Associates, here to help you get better because you deserve it. Call 215-471-4714.
For 20 years, Center City Medical Center has provided premium expert medical services for Philadelphia. Whether you need musculoskeletal rehab or an immigration physical, call 888-945-EXAM. Our board-certified physicians have more than 80 years' experience from post-injury rehab to DNA paternity testing. To make an appointment at one of our 3 convenient locations, call 888-945-EXAM. Get premium expert care. Center City Medical Center, serving Northeast, North, and Center City, Philadelphia. If you've been injured on the job and are entitled to workers' comp, you need someone fighting for you from the start. Call Jeffrey Gross, attorney at law. Don't rely on your employer or insurance company to get it right. Call 215-512-1500. If you're entitled to workers' comp or it's being challenged, Jeffrey Gross can help get the money you deserve, and he won't get paid unless you get paid. Call 215-512-1500. Jeffrey Gross, attorney at law, representing Pennsylvania's injured workers for more than 20 years. You've had an accident and can't work, but your legal case seems like it's taking forever, and the bills are piling up. At ThriveVest.com, we're here to help. If you have a pending lawsuit, call us at 888-697-7352. ThriveVest.com has flexible solutions to get you money now. And if your case doesn't settle or you don't receive an award, you owe us nothing. Call 888-697-7352. ThriveVest.com. Get the money you need to get on with your life.
The following is a paid program brought to you by My Philly Lawyer. The views and opinions expressed are those of the sponsor and do not necessarily reflect the views and opinions of the station and its management.
Need more legal answers? Here's more Court Radio with your host, Dean Weitzman.
Good morning and welcome back. It's Dean Weitzman and this is Court Radio. It's Sunday, May the 22nd. It's gloomy out, folks. Sit tight, relax, and enjoy Court Radio. If you've got legal questions, we probably have the answer. All you have to do is give us a call at 215-227-2727. There's my explosion. Okay, so we're talking to Irina Shiloh from My Philly Lawyer, who does the domestic relations for the firm, and she's been tackling questions about custody and paternity and support. So we're going to turn our question now to joint custody in Pennsylvania. For dads, especially, is it hard to get joint custody?
There is no discrimination between the parents. Joint custody depends on whether it's in the best interest of the child. That's always the standard. So a court will evaluate 16 different factors. It's actually 15. The 16th one is sort of like a catch-all phrase that says anything that's relevant. And the judge will examine both parties. If they have lawyers, the lawyers will examine them and look at evidence and decide who's the better parent or whether it's in the best interest of the child to have joint custody. It's not always easy to get joint custody if you live far away from the other parent, especially if the child is going to school, because how are you going to drive the child? So it's really important. This is why I want to take cases early in the separation period, because I advise people not to move far away, to stay within the same school district, and to basically petition for joint custody. And there's physical custody and legal custody. Joint legal custody is usually granted, and it means making important decisions about the child. But physical custody means who spends time physically with the child.
Right, and joint physical custody means that each parent is pretty much going to have the child half of the time.
Yes, and it can be what we call the 2-2-3, meaning 2 days with mom, 2 days with dad, weekend with mom, and then it reverses. Or you can alternate weeks.
Okay. Now, what about sole physical custody? Do dads get sole physical custody? Is that something that the courts frown upon?
Yeah, courts do frown upon sole physical custody. It would have to be something. There would have to be a big reason for that. The other parent would have to be really a bad, unfit parent to lose completely custody.
What happens when one spouse, catches the other spouse cheating and they really hate them and they think that they're just bad person? Does that impact the custody?
No, courts don't care about the problems between the parents, and they will often scorn the parents for fighting, especially if they fight in front of the children. They always say, you two, we know that you hate each other. That's why you're in court. But you have to find a way to communicate in a civil way for the sake of your children. You can't be selfish like you are.
Okay. So when one spouse gets all this information about the other spouse, but it really has nothing whatsoever to do with that person's ability to parent or their relationship with their child, the court would find that to be irrelevant.
Yes, hostility between the parties is actually relevant, and it is one of the factors. And I'm still not sure how they evaluate that, but I think because usually it's so mutual that you can't attribute it to one parent as opposed to the other. But if, say, one parent is very hostile and the other one is not, in theory, they would consider that in favor of the parent who's being nice.
Got it. So it pays to be nice, folks.
Well, I'm not so sure about that.
All right. What happens when one parent decides, hey, it's in the best interest of my child for him or her to go to private school, puts the child in private school? Can that parent force the other parent to pony up some money for that private school?
Yes, especially if the child has already gone to a private school. So let's say that you live in a place where the school district is not that good and you want your child to go to a private school, Catholic school or whatever. And if the child has gone to that school, attended it for several years, the other parent can't say, oh, well, let my daughter go to a public school because I don't want to pay. The court will force you to pay the tuition. It will be in proportion to their respective incomes.
Okay, but what about the scenario where they've never been in private school? You get separated, and then they decide, I'm going to stick the child in private school.
Yeah, it happens a lot, and they go by case. They have to decide, is this in the best interest of the child, or is it for religious reasons? So, for example, when it comes to religion, the court can't really interfere. They can't tell you, no, don't put your child in a Catholic school if that's what you want. But they could compare school districts, the public school district with the private and say, well, yeah, we think this is better and it's not that much and you can afford it. And so they try to work it out.
All right. So the answer is you're probably going to get hit for an increase in support. That's the answer. As long as it's in the best interest of the child and there's some justification for this. Now, it may be a different scenario if, you're in a blue ribbon school district and you move the child after the separation into a school that's charging, $50,000 a year, and you really can't afford it. So as Irina says, each case on its own merits and facts, but, for most circumstances, you're going to pony up a little extra cash. All right. I represent a father, and I represent him because he was involved in a very, very nasty car accident, and I secure a $700,000 settlement for the father, and the father receives this money. Mom finds out and wants to get an increase in child support. Can she do it?
She could. She could try, definitely. There is no law that talks about how your assets are considered, but they could be considered if you give a good enough reason. So, for example, if your income is very low, say $1,000 a month, and then you get a few million, obviously you're not poor anymore, so you should pay some of that money to your child or children. And how they calculate it, it really depends on the master or the judge. They decide how they will calculate it. There's no simple formula that says, okay, we'll consider that there's I don't know what the stock market would be, 4%, 5%, and you get that as your income. But they could consider it. They could simply say, from now on you're going to pay $2,000 a month because you got this money.
All right. So you're not immune, and again, that's why it's so important to have competent legal representation, because there's so many kind of little pitfalls waiting for you along the way. And folks, I know what happens. The money's a little tight, and they decide, hey, I got to cut a corner here or there. I'm going to try this on my own. I'm smart. I can handle this. But, even if you're smart, you're not a lawyer. And even if you're a lawyer, it's your matter. You're emotionally involved in it. You need to step back and let somebody else worry about the details. It'll work out a lot better for you if you do. And all you have to do, if that happens, is to give us a call at 215-227-2727. And that brings up another point. If somebody makes that phone call today and they ask for you, how long before you get back to them?
Oh, I call them as soon as I can. If I'm in court, then as soon as I get out of court, I'll call them sometimes on my way home from the car. So, yes, I call people almost immediately.
There you go. So if you want immediate attention, all you got to do is call that number and ask for Irina, and she'll get right on it. Let's talk to some callers. Let's see here. Let's talk to... All right, we have another Lori on line 3. Wow, what are the chances of that? Lori, welcome to Court Radio. How are you?
I've been better, thank you.
Oh, good. All right. So, you're from Gilbertsville, huh?
Yes, I am.
Wow, that's quite a ways away. Where's Gilbertsville?
It's right out about 30 minutes outside of Collegeville, PA.
Okay.
Outside of Piketown.
Outside of Pottstown. All right. What's the question, Lori from Gilbertsville?
My question is, what lawyer will I need? I'm a nurse in the prison system, and I was administering medication in one of the pods. When I was done, I knocked on the bubble where the CO stays, about to tell him about an incident that happened to me at the last pod with the inmate. And he directed me to go back. He demanded that I go back to another pod to give out more medication to some prisoners that just came in. But what happened was he told me that if I did not go, he wouldn't let me out. He did not let me and my trainee leave. We were stuck there for over 15 minutes. I had no phone. We can't carry phones. We have no radio. I knocked on the bubble again. He didn't call a nurse's station. He had us locked in there for over 15 minutes against our will.
Okay.
I'm the second nurse that he did this to within 7 days.
Okay, well, let me ask you what your relationship is to the prison? That's the first thing. Are you an employee of the prison?
I am a nurse for the agency that works inside the prison for the nursing system.
Okay. So you're an independent contractor who comes into the prison system.
Well, the agency, Prime Care, the agency that I work for, they work within the prison system. I work for them.
Okay.
So I'm a full-time employee that's at the system every single day.
Right. So it sounds to me like that relationship is a one of an independent contractor, and you're not a direct employee. Because the reason it's important is this. If you're an employee of the prison system, if it's deemed legally that you're an employee of the prison system, and even if you don't get your check from them, if they control every aspect of your job, you might still be deemed an employee. But if you are an employee, then you can't sue coworkers, and you can't sue your employer, the Commonwealth of Pennsylvania, let's say, or if it was a private prison, you couldn't sue the private prison. You can't sue your employer or coworkers. If you have a employee-employer relationship, then you must work your differences out through workers' compensation. And therefore, you would file a workers' comp claim if and only if whatever damages he caused you to sustain prevented you from doing your job. So let's say your anxiety was off the charts and you needed to have psychiatric intervention, and the idea of going back into the prison was so distasteful and it caused you so much heart palpitations and problems, then maybe you couldn't do your job for a period of time. For how long, I don't know, but then you might have a workers' comp claim, but you wouldn't have a third-party case or a claim for damages for negligence against your employer. Now, if it isn't your employer, then you do not have a workers' comp claim per se, but you may still have a workers' comp claim against the company that hired you as a nurse if you can't do your job, but you also may have a third-party case against this CO and the prison system for his actions that day. But again, as we talked earlier about a medical malpractice case, I have to remind you that your case is based on two things. One, his actions, which sound egregious, and I'll grant you that. And two, the damages that flowed from that action. And so 15 minutes, somebody might say, well, that's bad, but, it's not that bad, and it's probably only worth, maybe a few $100s for your inconvenience. Maybe not even that. Or maybe it's worth a few $1,000s. I don't know. Again, it depends on what your damages are. And damages need to be proved usually by experts. And so you come in with your symptoms, but you need a doctor or other type of professional to treat you for those injuries so that you can establish what your damages are.
Okay.
Because without damages, you only have half a case. You have the action, but you don't have, the court can't award you anything for that. I mean, they're not just going to reprimand this person. You don't go to court to get somebody reprimanded. Although in this case, maybe the honest answer is forget about lawyers and forget about trying to make a claim. You just need to report him to his superiors.
I did.
Okay.
I did. I filled out the paperwork. I reported him. The nurse that it happened to 3 days earlier, she also did documentation on him. He's still there. Nothing ever happened. If something would have been happened, if something was going to happen to him, it wouldn't have happened to me 3 days later.
Right.
I reported it to the DON, the person in charge. She told me it's their house, and I told her that's not good enough, for it to be, meaning it's their house, it's the prison system. And I know that what we do is all dictated by the guards, not the COs, but the captains and lieutenants. They tell us what we're allowed to do and what we can't do. But and then we sat down with the captain, and he never mentioned anything about me, the other nurse that was there, and my trainee being held against our will. None of that was ever touched. It was just said that he's still there. This particular guard, he's still there. He's still working there.
Yeah, well,
you know,
I would
holding us
expect
against our will.
I would expect him to still be working there, probably based on what you described. But that doesn't mean he doesn't have a reprimand in his personnel file. It doesn't mean that they're not pursuing things, and a lot of what they might be doing or did do is protected by HIPAA or by confidentiality.
Right.
So you may not know if he had some, bad, mark put against him. You simply may not know that, but I'm sure it didn't go unnoticed. If not only you, but a second employee nurse made the same complaint about the same person, I have to believe that they have a note on his file, and if he's not losing his job, he's been reprimanded and maybe had some consequences from this. But we got to run. Thanks for calling, Lori. Have a great Sunday, and I hope things go better at work. Take care, babe.
Bye.
Bye now. All right, we're going to be back in 2 minutes right after this station break.
You were just hurt. It's not your fault. You're in physical pain. How do you get better? Who is going to help you recover? West Philadelphia Associates has highly trained doctors and staff that can help you today. Don't wait at a hospital. West Philadelphia Associates will work with your attorney, providing documentation of all injuries and the best plan for treatment to get you back to the life you deserve. With diagnostic studies to better detect injuries, West Philadelphia Associates doctors and staff will help you recover. West Philadelphia Associates, here to help you get better because you deserve it. Call 215-471-4714.
For 20 years, Center City Medical Center has provided premium expert medical services for Philadelphia. Whether you need musculoskeletal rehab or an immigration physical, call 888-945-EXAM. Our board-certified physicians have more than 80 years' experience from post-injury rehab to DNA paternity testing. To make an appointment at one of our 3 convenient locations, call 888-945-EXAM. Get premium expert care. Center City Medical Center, serving Northeast, North, and Center City, Philadelphia. If you've been injured on the job and are entitled to workers' comp, you need someone fighting for you from the start. Call Jeffrey Gross, attorney at law. Don't rely on your employer or insurance company to get it right. Call 215-512-1500. If you're entitled to workers' comp or it's being challenged, Jeffrey Gross can help get the money you deserve, and he won't get paid unless you get paid. Call 215-512-1500. Jeffrey Gross, attorney at law, representing Pennsylvania's injured workers for more than 20 years. You've had an accident and can't work, but your legal case seems like it's taking forever, and the bills are piling up. At ThriveVest.com, we're here to help. If you have a pending lawsuit, call us at 888-697-7352. ThriveVest.com has flexible solutions to get you money now. And if your case doesn't settle or you don't receive an award, you owe us nothing. Call 888-697-7352. ThriveVest.com. Get the money you need to get on with your life.
The following is a paid program brought to you by My Philly Lawyer. The views and opinions expressed are those of the sponsor and do not necessarily reflect the views and opinions of the station and its management.
Need more legal answers? Here's more Court Radio with your host, Dean Weitzman.
Good morning and welcome back. It's Dean Weitzman, and it's still May the 22nd and still gloomy outside in Philly, so hang tight, listen to Court Radio, and enjoy the hour. We're talking to Irina Shiloh from My Philly Lawyer, and we're talking about domestic relations. Good morning and welcome back, Irina.
Good morning, and thank you, Dean.
Folks, if you've got legal questions, especially about custody and child support, all you have to do is give us a call at 215-227-2727 and ask for Irina. All right, let's talk to Joe from North Philly on line 2, Eric. Good morning, Joe. Welcome to Court Radio, and thanks for your patience. Oh, Joe. Yo, Joe. What's up?
Man.
Woo. I know. It's been a long time you've been sitting on phone.
Yeah, I was over there doing something in the kitchen. I was like, well, maybe one day they'll call me. Okay, cool.
All right. We're here. We're here for you, Joe. Give us your question.
All right, look, disabled child, autistic, over 18. We want to send her to a state-run place as they do, because they're more therapeutic, more beneficial for her growth. Is custodial parentage an issue in that point? I mean, how is or is it just, does it become moot at that point? If she's in a gated community, state-run facility, is custodial parentage, is it moot, or is it some kind of consideration, or what is it? I don't know.
All right. Well, let's let Irina try to tackle that.
Yeah. What is the question? I don't understand.
Are you saying, Joe? Are you going to still be responsible financially for your child?
Well, yeah. We're presumed. I presume to be, yes.
Okay, yeah, I think that the financial responsibility when you have a disabled child does not end at their 18th birthday. Am I correct?
know, but I'm saying custodial parentage. I'm not even talking about the financial responsibility. Well, she, in fact, gets a Social Security claim off of my claim anyway.
Okay.
But, we're in no way negligent. As a matter of fact, we want to know, how the math works out, or how what the law allows. But I just want to know, as far as custodial parent, we're both custodial. It's a moot point because nobody's fighting. You know what I mean?
Here's the answer. The answer is if you and the child's mom decide to put her into a state-run facility, then you're no longer the custodial parent. That responsibility falls on the institution. As a custodial parent, you have to make sure your child is well cared for, has a place to sleep, and has 3 meals a day, and all the things that we take for granted as parents. But when you're no longer the custodial parent because your child doesn't live with you or his or her mom, then that responsibility would fall on the institution.
Roger that. I presumed that, but I never saw it in writing. Guardianship and power of attorney might be another avenue if I really wanted to have something to say about anything. I'm presuming. I'm just running my mouth at this point because I didn't read it anywhere.
Yeah, well, guardianship deals with making decisions for your child, okay? And for your disabled child, after 18, there may need to be a hearing of competency. I don't think that the law would legally presume your child to be incompetent after she turns 18, regardless of her medical condition. I think that you would have to petition the court to become the guardian of your child so that you can make decisions for her.
Yeah, that concurs with what we previously heard. I just want to see if there's any new information I would get from you. And I do thank you for taking the time, All right. I heard something said earlier about dual power of attorney. I never heard that before.
Well, for whom power of attorney?
Because that's something I might be able to...
Your daughter can't give power of attorney if she is mentally disabled.
If she's power of attorney is when you, as the one party, allow another party to make decisions on your behalf. You sign something called a power of attorney. If she's not competent, then you need to go about it the other way, which is the way I told you originally, which is to file a petition with the court and request that you be appointed her guardian, or the mother be appointed, or both of you be appointed the guardians of your child. And if she's got a severe disability, that isn't a very difficult burden to meet. You just need a doctor to support you in that process. And so it's not that difficult. It's fairly easy to do.
Well, I do want to look into dual guardianship because I don't want there to be a conflict between me and the mom. I don't want a power struggle to ensue. So I would always go for that dual. I'd rather lose a battle to win the war. So perhaps could I call Miss Irina?
You can.
Yes.
Just give us a call during the week at 215-227-2727. Joe, be well. Thanks, brother.
This on.
All right, take care.
Bye, Joe.
Bye, Joe. That's it. Joe, done. We don't play. No, we're almost out of time. I can't believe how fast this hour goes. I want to thank you for schlepping in to be here live with me.
No problem.
All right. Folks, if you've got domestic relations issues, all you got to do is give Irina a call at 215-227-2727. And I know most people at some point in their lives have domestic relations issues.